everyone, good evening and welcome back to Thorough Newspaper Analysis. Now today is 21st of July and this entire video series it's brought to you by LawSikho. Now let's head to the agenda for today. The first is the editorial segment and here for discussion we have this article which is titled as India's Data Protection Law, It Needs Refinement. See, here the author has suggested that there are two glaring gaps in the data protection law. So, what are those glaring gaps and what can be the possible solutions? That is going to be the point of discussion for today. And this is in light of the fact that, this bill, it is likely to be tabled before the Indian Parliament in the ongoing monsoon session. Secondly, we cover important news updates. And lastly, we talk about the legal news updates of the day. So let's proceed with the TNA, and this is the very first point of discussion for us. Let's start with the why of it first. So as I've already mentioned, the monsoon session of the parliament, it is ongoing. It started on 20th of July and it is likely to end on 11th of August. So with this monsoon session, this particular bill, the Digital Personal Data Protection Bill for the year 2022, it is likely to be tabled before the Indian Parliament. And therefore, the deliberation around this bill, it has become again the important point of discussion and deliberation. This is the third attempt by India at data privacy law, with the earlier edition being 2018 and 2019. So let's see as to what are the two gaps that the author has highlighted. The first gap, it pertains to the scope of this bill, and the author has highlighted that this bill, it covers only personal data and leaves non-personal data out of the bill's ambit, which is in essence harming user privacy. So what is personal data? What is non-personal data? How is the exclusion of non-personal data harming user? That is going to be our first limb of understanding. Second gap is that the Data Protection Board, it is not equipped with suo motu power to take up complaints. So how is it again harming user? That is going to be the second limb of our this article. Let's start with the scope of the bill first. In its scope and definition, this bill, it only protects personal data. So what is personal data? Any data that has the potential of identifying an individual, that is your personal data. And this identification, this may be direct or indirect as well. Now we also know that in modern data economy that we have currently, there are a couple of entities that use various data sets, including both our personal data and non-personal data, for the purpose of targeting, profiling, predicting, and monitoring user. Non-personal data, it is typically anonymous data that does not relate to a particular individual. So for example, aggregate data on products which numerous users look between, let's say, the time of 9 p.m. to 11 p.m. on Amazon. So that becomes your non-personal data. However, it is the argument of the author that often this non-data, personal data set, it is when combined with other data set, it can be used by a couple of identities, in fact, a lot of entities, I'm sorry, for the purpose of identifying an individual. So therefore, it means that non-personal data set, they can also be used for the purpose of directly and indirectly identifying an individual, which is what the definition of personal data is. So this means that if you are keeping the non-personal data set out of the ambit of the bill, this is going to harm for sure the user privacy. And the author further points out the fact that non-data, non-personal data, this was a part of the earlier editions of 2018 and 2019 editions, but for this time, this has been excluded. So, as a solution to this problem, the author has stated that a simple and effective solution, it would be to add a penal provision in the bill that provides for financial penalties on data processing entities for the re-identification of non-personal data into personal data. So wherever there is re-identification of non-personal data into personal data, then you put financial penalties on the entities which is engaging in such sort of practice, so that the user privacy is not compromised. Now, another gap is the fact that the Data Protection Board, it is handicapped since it does not have the power to initiate a proceeding out of their own accord. So how is this harmful? See, we know that even if, let's say, we're a student of the legal fraternity, even then also at times we're not aware of our right, and data processing, how data is processed, used by these entities, it is such a complex matter. So at times it might happen that the entities that we engage with, let's say our food delivery apps or any sort of other application, where they do make certain commitments for protecting our privacy, then also we never know that they can give our or trade our data for money with any other entity for the purpose of predicting user behaviors and a couple of other economic profits oriented purposes. So therefore, shouldn't this data protection board be given the authority of, initiating any sort of complaint with respect to any data aggregator or any data and processing entity, which it can see that, it is misusing the user data, which the user might not be in a position to identify. So let's say if my data, it is being misused by any app that I am interacting with, I might not get notice of that because I may not be equipped with the essential knowledge. But Data Protection Board, which is the apex body here, it may be in a position to identifying the risk of identifying the risk. So shouldn't it be given the the authority of suo moto initiating the proceedings against these data processing units? That's a very important question. In this respect, the author has drawn a parallel to the Competition Commission of India, whereby he said that this is, we know that this is the body which is responsible for the enforcement of the Competition Commission Act in our country. It has the power to take such sort of initiatives, inquiries, and complaints out of its own accord. And we've seen it utilizing this power a couple of times and frequently, which is right because it is implementing the very object of the legislation. So therefore, the author is saying that the bill, it should take into consideration the efficacy of the board in such a case and therefore should act upon the same. And with this, we proceed to the next segment for today. And now we proceed to the national news category for today, and here's the first update. The Finance Ministry, it has appointed Pramod Rao, who is the Executive Director SEBI, as a member of the Board of International Financial Services Center Authority. Mr. Rao, he has replaced Sujit Prasad, the Executive Director SEBI, who was appointed as a member representing SEBI in IFSCA in July of 2020. Earlier, he had served as the member of the Board of Directors of ICICI Securities Limited, ICICI Prudential Trust Limited, and ICICI Trustship Services Limited. As far as this authority is concerned, it is a statutory authority which is established under the International Financial Services Centers Authority Act of 2019. And the mandate of this act is to develop and to regulate the financial services, the financial products, and institutions in the international financial services centers. DD Sports, it has partnered with iStadia to broadcast the highly anticipated ninth edition of the FIFA Women's World Cup. iStadia, it has granted streaming platform which is called Fan Code as the sub-licensing rights for streaming, while the public broadcaster DD Sports, it has been entrusted with the sub-licensing rights for television broadcasting. As far as the Women's World Cup for the year 2023 is concerned, it kicked off on 20th of July in Australia and New Zealand. And in fact, this is the very first time that, this cup, it is being hosted by two countries with a newly expanded field of 32 teams. And this is a piece of information for your reference, just in case there's any sort of question in any of your exams pertaining to the formation of DD Sports. So it was formed on 18th of March in 1998. Moving on. NITI Aayog, it has released under the NITI Working Paper Series, the Techno Commercial Readiness and Market Maturity Matrix Framework, which is a pioneering assessment tool designed to revolutionize technology evaluation, foster innovation, and fuel entrepreneurship in our country. The working paper, it casts light on the historical evolution of technology assessment frameworks, including the technology readiness level, commercialization readiness level, and the market readiness level scales. INS Sayadri and INS Kolkata, which are in fact the two flagship ships in the Indian Navy, so they reached Jakarta to take part in a bilateral maritime exercise, which is maritime partnership exercise at sea with the Indonesian Navy for the purpose of further strengthening the high level of interoperability that both of these navies they have from the Middle East. So during the port call, the personnel from Indian Navy and the Indonesian Navy, they will engage in a wide range of professional interactions, joint yoga sessions, sports fixtures, and then apart from that, cross-deck visits. All of this aimed at strengthening the mutual cooperation and the understanding between the two navies. DG Rakesh Pal, he has been appointed as the 25th Director General of the Indian Coast Guard. He is an alumnus of the Indian Navy Academy and he joined the Indian Coast Guard in January of 1989. Apart from that, he was elevated to the rank of Additional Director General in February of 2022 and he was posted at Coast Guard headquarters in New Delhi. The officer, he holds the recognition of being the very first gunner of the Indian Coast Guard. Karnataka Chief Minister, he has launched the registration of the Congress government scheme which is called Gruha Lakshmi. This scheme provides for rupees 2000 monthly assistance to women head of each family in the state. The scheme, this was a part of the five main election guarantees of the Congress party made before its massive win in the May 10 assembly election in the southern state. Officials said that the scheme it is expected to benefit around 1.28 crore women, each of whom will receive 24,000 annually. In the slide, the state government, it had allocated rupees 24,166 crore for the scheme in its recent budget announcements. The Indian Navy, it gets its first barge of series LSMA 7. Contract for construction of around 8 ex-missile cum ammunition barge, it was concluded with this company which is called Seacon Engineering Projects Private Limited, Vishakhapatnam. This was in consonance with the Atmanirbhar Bharat initiative of the Government of India. First batch of this series, it has been delivered to the Indian Navy and this happened on 18th of July. The barge it has been built under the classification rules of the Indian Register of Shipping with a service life of around 30 years. Now with all the major and auxiliary equipment sourced from indigenous manufacturers, the barge it is a proud flag bearer of Make in India initiative of the Government of India and the Ministry of Defence. And this has brought us to the international segment for today. Sign language, it has become the 12th official language of South Africa. The president of South Africa, he has officially signed South African Sign Language as the 12th official language of the country. The move, it makes the country the fourth on the continent to have sign language as an official language following these three countries, Kenya, Zimbabwe and Uganda. South African Sign Language, it is an indigenous language that constitutes a very important element of South African linguistic and cultural heritage. It has its own distinct grammatical structures and lexicon and it is independent of any other language. Sri Lanka, it okays law on corruption in lines with IMF Plan. The Sri Lankan parliament, the island nation, it has attempted to overcome an unprecedented economic crisis and it is continuing to do so. The legislation, it is a part of the prerequisites of an International Monetary Fund bailout package, which was approved in March. And this was under which nearly $3 billion in government budgetary support will be dispersed in stages to the bankrupt nation. This bailout, it is due for its first review in September. And this is the last update in the international segment. So the United Nations General Assembly, it declared July 20th every year to be celebrated as the International Moon Day. This day, it is celebrated to mark the anniversary of the day when humans first landed on the moon as part of NASA's Apollo 2nd mission. Astronauts Neil Armstrong and Buzz Aldrin, they landed on the moon in a location that they then called the Tranquility Base, and this happened on 20th of July in the year 1969. The General Assembly of the United Nations, it declared it as an international day to be observed in its resolution on international cooperation in the peaceful uses of outer space in the year 2021. And with this, we proceed to the legal update segment for today. And here's an update coming from the Honorable Apex Court. So the Supreme Court has observed that the practice of summoning authorities of the state at drop of a hat, it undermines the majesty of the court. The apex court, it was of the view that insisting on the presence of the officers in the court, it wastes the very precious time that could well be spent on the discharge of their duties, and that such a practice, it must not be adopted as a routine or in a mechanical manner. The name of this particular matter is a State of Bihar versus Ghanshyam Prasad Singh. Another update from the apex court. So the Supreme Court has held that where a check is dishonored, the interim compensation, it can be directed to be paid only after the accused has pleaded not guilty as per section 143A subsection 1 of the Negotiable Instruments Act. In this present case, essentially, the court noted that the magistrate he had directed to pay 10% of the check amount before the plea of the accused was entered. So the court held that such orders being passed before the plea was taken into account, this is unsustainable in law. The name of this case is Pawan Bhasin versus the state of UP. And this has brought us to an end of our TNA. In case you want to get access to the free study materials that we provide or the TNA slides used in this video, you may scan the barcode or click on the link which is given in the description. And this is for the purpose of joining our Telegram channel where you can get access to both of these materials. These are the point of contacts in case you want to get in touch with us. Also, the link to yesterday's TNA based quiz, it is made available in today's description. Thank you for being with us.